Good afternoon, Your Honors. May it please the Court. My name is Garrett Ward, and I'm here today on behalf of the State of Tennessee, the matter of State versus Joshua Morris. With the Court's permission, I'd like to reserve 4 minutes of time for rebuttal.
Certainly.
Thank you, Your Honors. Your Honors, this Court should reverse the decision of the Knox County Criminal Court dismissing the State's indictment on collateral estoppel grounds, because that decision comported with neither the spirit nor the letter of Tennessee law regarding collateral estoppel. And I think perhaps the best place to start in this case is to sort of track the course of the of the singular but then multiple pieces of litigation that we have present here, because I think that really informs, in the State's view, why estoppel here was improper. So this case started as a singular piece of litigation in Knox County General Sessions Court. The State brought a DUI charge against Mr. Morris, along with an allegation that he had violated the implied consent law. At the General Sessions Court level, the Sessions Court bound over the DUI and found that the State had proven the implied consent violation. At that point, as was absolutely his right, Mr. Morris availed himself of sort of the expedited appellate procedure that is available following implied consent violations, and he appealed that violation to Knox County Circuit Court. And as this court is doubtless aware, Knox County has separate civil and criminal circuit courts, and the act that sort of set this dual court system up sort of separated them jurisdictionally as well. So the criminal court has sole criminal jurisdiction, the circuit court has sole civil.
So was the indictment handed down before the cases got separated?
It was bound over to the grand jury, and then it was separated, I think, within 10 days of the criminal court case being bound over. The indictment was returned in March of 2023, which is about 3 months after the cases were separated.
Okay, so we're using the term separated. How are you using that, Mr. Ward?
So when Mr. Morris appealed his implied consent violation, the implied consent violation went to circuit court.
How does it go separately from the DUI?
That's the procedure laid out for quickly appealing these implied consent violations in Knox County. So there's a 10-day window after the implied consent violation is found in which you can sort of appeal that finding, because immediately on the Sessions Court, finding that your license is subject to revocation, so you can quickly appeal that while the criminal case goes before the grand jury.
So it is common practice for an implied consent violation?
That's my understanding, Your Honor. This was a sort of a facet of law that was unfamiliar to me until this case, but from talking to prosecutors that handle DUIs in the Knox County DA's office, that's my understanding. Is that
so the prosecutor was aware of the appeal of the implied consent violation?
Yes. To that end, Your Honor, the defendant files a motion for summary judgment in Knox County Circuit Court about the implied consent violation in January of 2023. About 2 months after that, before there's any ruling on the motion for summary judgment, the Knox County grand jury, as was its purview, as was its duty, impaneled and returned a presentment sort of formally charging Mr. Morris with driving under the influence. About 16 months after that, the Knox County Circuit Court granted his motion for summary judgment.
Was the circuit court aware of the indictment or presentment? I'm sorry.
It's unclear whether the circuit court was certainly aware that there was a DUI case. It's not clear to me from the record whether it was aware.
Was the prosecutor aware?
That there had been a presentment?
Yes.
Yes, Your Honor.
The prosecutor didn't tell the judge, the circuit court judge?
From my recollection of the record, and I'll certainly yield to it because it will be more precise than I will, from my recollection of the record, no.
I'm unfamiliar with this process as well, so I was just trying to figure out if there was in fact a presentment.
There was.
You're right. The circuit court's knowledge of the presentment.
I'm not entirely, I can't say for certain to what extent the circuit court knew, but for the purposes of collateral estoppel, I don't think the circuit court's knowledge or lack thereof is really determinative either way. If the circuit court knew of this presentment, I don't know that that would necessarily prevent it. In fact, my contention is certainly not that the circuit court would necessarily then be prevented from ruling on the motion for summary judgment. Whether it knew about that or not, the circuit court's ruling is not. I mean, it's obviously connected to this litigation because it was the basis for estoppel. We're not here seeking to overturn, obviously, the circuit court judgment granting the motion for summary judgment. The problem occurs when that judgment was then used to collaterally estop the state from, and I'm quoting the criminal court here, relitigating the issue of probable cause. And that's a problem for several reasons, and I want to focus on two. One more rooted in the letter of the law, and one rooted in sort of the spirit of what collateral estoppel is supposed to be applied to. And I'll start with the letter of the law. There are 5 requirements for collateral estoppel in Tennessee, and these are laid out in the Arnold case, which is cited in my brief. Those requirements are identicality of issues, that the issue to be precluded was litigated on the merits in prior litigation, that there was a final judgment on the issue in the prior litigation, that the party being estopped was a party in prior litigation, and that the party being estopped had a full and fair opportunity to litigate it. And the state's principal problem here, Your Honors, arises with the first requirement, and that's of identicality. In his motion for summary judgment before the circuit court, Mr. Morris, as was absolutely his right, said the state has not proven probable cause as relevant to implied consent. And probable cause for implied consent is a pretty unique thing. The implied consent law demands that Tennessee motorists comply with requests to perform field sobriety tests if those requests are given by an officer who has probable cause at the time the request is made to believe they have committed one of a number of crimes, including DUI. So that's the proper probable cause inquiry in the implied consent context. That's laid out in the implied consent statute, that probable cause requirement. And that's a little peculiar, and it's a little different than what probable cause is in general in the criminal context. In the criminal context, probable cause is generally a sort of a grand jury, at least in this case, was a grand jury matter. The grand jury impaneled and returned a presentment, and that's sort of the grand jury's formal finding that there's probable cause. And although the phrase probable cause is used in both contexts, there's a pretty crucial difference, and that's in the probable cause inquiry in the implied consent context being rooted, not in the sort of whole field of evidence available to the state, but rooted in the knowledge and the mind of the officer at the very instant the request is made. So let me perhaps illustrate with a hypothetical. If Officer A conducts a traffic stop and forms in his mind probable cause to conclude that a driver is driving under the influence, but while he's sort of attending to matters of the traffic stop, Officer B shows up, doesn't communicate with Officer A at all. Officer B does not form probable cause. And then Officer B goes to this motorist and asks him, conduct a field sobriety test, and the motorist does not comply. That cannot be the basis of a probable cause violation because Officer B did not have probable cause at the time the request is made. Contrast that with how the value of the two officers and their knowledge and their having or not having probable cause would be relevant in a grand jury proceeding. In a grand jury proceeding, the state can present all of the evidence available to it to conclude or to establish not what a certain officer knew at a specific point in time, but more generally whether the state has the requisite evidence to establish probable cause that a crime was committed.
But what did the circuit court find?
So the circuit court's order is not precisely rooted in probable cause as would classically be relevant in the implied consent context. And I'll fully admit that, but for collateral estoppel purposes, Your Honors, that only cuts in the state's favor because to the extent that the circuit court is making more generalized findings about the state's probable cause evidence in total, that is beyond the scope of what it needed to actually needed to decide to grant the motion for summary judgment, because the probable cause inquiry should have been limited to what did Officer Pierogi know, that's the officer in question, at the exact moment he made this request. If there's other evidence that I believe there's actually an affidavit suggesting that
Yeah, I had
after
a
officer.
question about that.
Certainly.
What exactly happened with the refusal to consider the affidavit?
The court simply refuses to consider the affidavit because I believe it wasn't presented at the hearing and because it spoke to information learned by this officer after the request was made.
When was it presented to the circuit court?
I forget the exact date, but it's while the motion for summary judgment was pending. So before the motion for summary judgment was granted, the affidavit was presented, and then the court sort of acknowledges it in its order and says, but I'm not going to consider this. But so to sort of sum that up, Your Honors, we have two, although both inquiries deal with probable cause, one is limited in scope. It should be limited in the implied consent context, specifically to what was known by Officer Pierogi at the time he made this request. Other information that was perhaps learned by Officer Pierogi afterwards is irrelevant to implied consent, probable cause, but is critically relevant to the more general probable cause finding returned by the grand jury. And if I may, I want to spend the rest of my time talking about the grand jury here, because that's maybe the more fundamental problem with this case. This is the sort of spirit of the law problem I was mentioning earlier. At the time that Mr. Morris sought to collaterally estop the state from, quote, litigating the issue of probable cause, the state had already successfully litigated the issue of probable cause, and it had won. In March 2023, the grand jury returned a presentment, and that is a formal finding of probable cause. 18 months later, Mr. Morris comes into criminal court with an order from a civil circuit court in Knox County and says, state, you should be collaterally estopped from proving probable cause, but the state has already done so. The state isn't litigating the issue of probable cause. The grand jury has found it. And as I'm sure Your Honors are well aware, there's a number of cases that say it. The one that springs to mind for me is one of the Tony Carruthers opinions. Tennessee law doesn't condone sort of peeking into the sort of in most circumstances, the grand jury's probable cause finding. Once the grand jury finds probable cause, absent circumstances dealing with sort of malicious concealment of evidence. But by and large, once the grand jury returns a probable cause finding, the issue is concluded.
Well, why didn't the state argue that in the circuit court?
So in the circuit court, Your Honors, the circuit court was sort of entitled to grant the motion for summary judgment on implied consent.
So what to what end? To do what with that?
Because that would allow him to get his license back. But if the circuit court thinks that Officer Pierogi did not have probable cause at the time he made the request, it isn't super relevant it isn't really relevant that the sum total of the evidence might have established probable cause, which it did in this case. All that matters is what Officer Pierogi knew at the time he made the request. And that's what the circuit court should have been focusing on.
Let me tweak your hypothetical.
Certainly.
Let's say you had one officer, okay,
Mm-hmm.
Pierogi. Let's say you had one officer who thinks he has found a drunk driver and walks up, and instead of conducting the observations and the other things that typically lead to probable cause in such an arrest, just says, take these tests, or I'd like to take your blood, and if you refuse to do so, you lose your license. The defendant says, or the suspect says, no. Okay. And then later it's developed the defendant either says, I'm drunk, or there's other independent probable cause that leads to show he's driving under the influence. So the implied consent request in that case would be invalid because there wasn't PC at the time the same officer asked, but still potentially could there not be a criminal case later?
Precisely, Your Honor. I think that's exactly what the law says, that for implied consent, we are solely focused on what the officer knows when the request is made, because it is requests by officers who possess probable cause that sort of trigger in Tennessee motorists the duty to comply with this request to do a field sobriety test. And I mean, that speaks to why I think these issues are different. Overall, probable cause is evaluated by the grand jury is just different than what the circuit should have been considered. But more fundamentally, the grand jury has already said there is probable cause. So we're not collaterally stopping the state from litigating it in this action. We're peeling back the finding of a grand jury in a way that Tennessee law generally says is impermissible. And that should be a basis for reversal here, apart from the deep reservations the state has about identicality. If the state has litigated an issue and won, it's simply not collateral estoppel to then, we're dealing with a different legal doctrine than collateral estoppel when 18 months later a criminal court says you're not able to establish it. The state's already established it. It's not sort of continually doing so. The grand jury made its determination, and that should have been the basis on which the trial court rejected this attempt to collaterally estop the state. If this court has no further questions, I'll reserve the remainder of my time. Thank you, Your Honor.
Thank you, General. These gentlemen from Knoxville, and good to be speaking from this side. You know, obviously the air is the same, but it was almost confusing when I went to that side when I walked in this morning. Interesting conundrum that we present you with, and one that I thought was particularly well thought out by both Judge Stevens and Judge Thomas. Obviously, we use collateral estoppel as a defensive measure in this particular situation. And what the court will see when the court delves into the record relative to this is not a situation in which the state was taken by surprise or they were not adequately represented. In fact, the court will quickly glean that they were represented by a member of the Knox County Attorney General's office specifically dedicated to DUI enforcement and prosecution. That being said, as has been indicated, there are different ways of pursuing the appeal of an implied consent violation, and we timely filed, as we are allowed to do so, the appeal relative to the implied consent to circuit court. It was assigned randomly. We ended up drawing Judge Deborah Stevens. We then engaged in some preliminaries, and at a point in time, we filed a Rule 56 motion for summary judgment, upon which we relied after receiving the transcript of the preliminary hearing down in the Sessions Court. And if the court will examine the order, which you will, it's part of the record, with regards to what Judge Stevens said and what Judge Thomas relied upon, it dealt with physical control. And you will hear discussions of keys in the fact that no one took the time on behalf of the state to assess as to whether or not those keys went to that vehicle, that there was no indication the car wasn't idling, the car wasn't running, the car hadn't been driven in, anything of that nature. That being said, particularly with regards to the rules of civil pleading, as in all sets of rules, there are deadlines, and deadlines have to be met, and they're expected. And as they say, what's good for the goose is good for the gander. If the state doesn't meet their deadlines, then they incur the same penalties that a defendant would relative to the same. So that being said, the case was argued in front of Judge Stevens. It was taken under consideration. There is, in fact, an indictment that was returned, but this court's well aware that an indictment is not a final judgment, is not a final determination. As Judge Wackler said, you could indict a ham sandwich, quite frankly, if you wanted to. But that being said, in this particular case, that does not preclude this situation. The other aspect
But it is
of
a finding of probable cause.
It's a finding of probable cause. That is correct.
Under the structure that we have in this state to charge criminal cases.
Sure, absolutely. I would wholeheartedly agree with it. And then that posits the question, if the state's sitting there going to rely upon that, then why didn't they file something in the civil action? And then, if in fact, when they find the civil action decided not in their favor, why didn't they appeal it? There's a 30-day period of time. They chose to ignore that. And, you know, I think when you trigger upon the words that are contained in the state's own briefing, where they say they weren't incentivized, it makes me think of our athletes with the University of Tennessee when they leave the locker room. I will give my all for Tennessee. Evidently, all wasn't given in this particular case because they, quote unquote, weren't incentivized. You know, when we litigate, we are charged with the responsibility of doing the best each and every time we hit the court, not just what we feel is appropriate. They could have filed a motion to stay. They could have filed something with regards to that. They chose not to address that. And I can't sit there and question what their decisions is. I had an opportunity to represent Mr. Morris, and a responsibility, and mine was to represent him in the manner and method in which I saw best. And in this particular case, yes, that is a non-final determination. But when you look at Judge Stevens' ruling, which is incorporated in, the whole issue dealt with physical control. So when you deal with the identical issues in this particular case, there's no question about it's effectively the same parties. It is a unique situation that likely this court will never deal with again, because quite frankly, I think the state will learn from the set of circumstances they dealt with that created it. But Mr. Morris shouldn't be penalized. If the legislature did not want this pursued in this method and manner, then they should change the law. But he had the right to pursue it. And it's mentioned in the state's brief.
But what exactly was he pursuing? Was he not just pursuing the suspension or revocation of his license?
And in order to do so, he had to challenge the issue of probable cause, whether or not there was probable cause to establish physical control, and that's actually contained in the decision by Judge Stevens.
Okay.
And so that's where they end up in their problem with regards to it. So in the hypothetical like what you proposed with regards to it, as far as just a minute ago, you have to go step by step by step. And I mean, the facts are going to be undisputed that Mr. Morris is found asleep, resting, whatever you want to characterize it, at a fuel station. They don't bring anything else in with regards to that. So we're left on effectively that naked transcript at that part and point, and that's what Judge Stansberry bound the case over on. They never established physical control of the vehicle. Sitting in a vehicle and sleeping in a vehicle is not a crime in and of itself. And in order to establish quote-unquote physical control, the court's aware of all of the case law and the progeny that follows with regards to that. The state chose not to do that. And then when we appeal that and we challenge that with regards to that they couldn't get to the implied consent request because they didn't establish physical control, that's what Judge Stevens' decision was upon. So then we took and we utilized that following the affidavit as a defensive collateral estoppel to the state. Had the state, I guess, woulda, coulda, shoulda done something else, they wouldn't find themselves in the pickle that they're in. But in this situation, they've got a judgment of a circuit court judge that literally is on all fours relative to this issue of physical control.
Well, that's what I want to ask you. So is it your contention that the probable cause finding in the circuit court and its parallel in the criminal case are exactly the same?
Characterizing it as the finding of the lack of probable cause, but
Yes,
yes.
I'm sorry.
I mean, and I wasn't trying to correct, but I also didn't want to agree to something with regards to that. Yes,
Sure.
Absolutely, because if you look at the reasoned opinion by Judge Stevens, it tracks all of those steps with regards to what is required and to get to that.
All
And
right. So I understand your argument that the circuit court's finding collaterally estops any further prosecution in the criminal case. Is that fair?
That is a fair summation of the same based upon the requirements with regards to collateral estoppel. And I know years ago when that Bowen case came out, I was at a seminar and I hearkened back. I'm sitting there listening to that and I'm like, you know, I'm going to have the opportunity to use that the other way around because what's good for the goose is good for the gander.
Congratulations.
And
So-
I literally remembered that, and that's where this fact, instead of circumstances, presented itself. And so I understand, at least in front of the Tennessee courts, it's a case of first impression with regards to it. We've got the advisement of Bowen, but we've also cited a number of federal jurisdictional issues with regards to where it has been used to preclude various collection efforts and things of that nature with regards to criminal fines and things of that nature. And then as far as to distinguish anything that the state says with regards to the juvenile court proceedings, those are two completely different types of proceedings.
Okay.
So
I get the argument now. I get the logic. So based upon that logic, why would the grand jury's finding not collaterally estop the circuit court's finding if they are in fact the same?
I think there might be a circumstances of that, but that's not a final judgment. In the situation where it is the circuit court, that is a final judgment. If the state had jumped in there within the 30 days when Judge Stevens put it down and appealed, I don't think we'd be here. They didn't do that. And that's the problem that you get to. I mean, a grand jury finding is not a final judgment, but by definition, in order for collateral estoppel, we've got to have a final judgment. And the only final judgment in this case, absent Judge Thomas's subsequent ruling, is the ruling by Judge Stevens. So, albeit, you know, it's kind of like when we talk about the spirit of the law and everything of that nature, to me, that's kind of like saying judicial discretion. And I've always wanted to say that in court. I know this isn't a discretionary issue, but that being said, you know, it is a question of the application of the law. And I just cannot help to think that the sword is sharp on both sides. That, I mean, it doesn't get to get swung by the state and then us not be able, on behalf of the criminally accused, to use those green books and swing it back the other way.
Okay.
So that's where I'm at with regards to this.
So just a question. You started out talking about deadlines and same prosecutor or a prosecutor from the DA's office was in the civil case too. It was unclear to me, at what point was the affidavit from Officer Pierogi presented to the circuit court?
I cannot tell you the exact date and time, and I regret that with regards to that. Once I heard that come up as far as dealing with that, the record should speak as to that, and I am sorry, I'm not going to represent one way or the other with regards to it. The issue came down, as I recall, that in order to submit affidavits for Rule 56 consideration, certain prerequisites have to be made. You can't effectively compound multiple hearsay in it. There's requirements. You have to go as far as step by step by step, and those weren't done. But that being said, it was excluded. And so if the state thought that was error, then their remedy was to appeal Judge Stevens' decision, not to allow it to rest, right? So if there was a Rule 56 that they disagreed with and said, hey, we should have been able to get Pierogi's affidavit in, then their remedy was to either move to reconsider and or to appeal that, but they didn't choose to do so. And so with regards to the issue of Pierogi's affidavit, at least from our perspective, it's moot now because they allowed their time to go. I intentionally, and quite frankly, waited until after the time for appeal was passed with regards to when I filed my motion with regards to the dismissal of the criminal case to use the collateral estoppel defensively, because had I filed it beforehand, they would have had a fail-safe in that they could have just gone and appealed that. And so that being said, I mean, whether or not it's calculated or not, I mean, that's what we're supposed to do with regards to the utilization of the rules to the best interest of our client. And that was what was done. So from a timing perspective, it was done after the decision of Judge Deborah Stevens was final.
Okay.
Court have any other questions? It is good to be on this side. Thank you.
A couple of brief points on rebuttal, Your Honors. There's been some amount of discussion in this argument about the state's failure to appeal the implied consent violation. Maybe the state should have appealed it, but what that decision really isn't is relevant to whether or not collateral estoppel is appropriate in this case. If I was up here trying to undermine in this appeal the implied consent violation, it would matter a lot that the state didn't appeal that. But in terms of is collateral estoppel appropriate?
Well, I guess the only thing that gives me pause, and this is going to take a minute to get into this record here, was the summary judgment order overly broad? And if it was overly broad, it did capture aspects of the criminal probable cause determination.
I think it is probably overly broad, Your Honor, but for collateral estoppel purposes, the second requirement of collateral estoppel is that all the issues decided in the prior litigation were necessary for its decision. And to the extent this order is overly broad, which I agree it appears to be, we're talking about things that are, in my view, well beyond what Officer Pierogi knew when he made this decision. That's a problem for the defendant for collateral estoppel purposes, because things beyond sort of whether or not the state had probable cause at any time other than the exact instant Officer Pierogi makes his request, those aren't necessary for the probable cause determination for implied consent.
But I guess if you don't appeal the broadness of the order, doesn't the criminal court become stuck with it?
Absolutely not, Your Honor. If we don't appeal the broadness of the order, then we lose the implied consent violation, but for collateral estoppel purposes, the only thing that the state can possibly be estopped on here are things that were necessary for the court's determination of the issue before it. So if the court makes a bunch of findings that are sort of wholesale, far afield from the issue in front of it, absolutely not is the criminal court bound by those, because we'd be talking about things that weren't necessary for the decision rendered in the other court. And I guess I want to conclude my time by sort of reiterating the timeline in this case. In March 2023, the grand jury says, state, you have probable cause. 18 months pass. And at that point, the defendant says, state, you should be collaterally estopped from litigating this issue. The state's not litigating it at that point. The collateral estoppel order rendered by the criminal court says, state, you're estopped from litigating this issue, but the state wasn't litigating the issue. It had been litigated and the state had won. I understand perhaps this court has concerns about the state's failure to appeal the implied consent violation. Those do not matter a jot when it comes to was this issue being litigated? It was not. And if the issue isn't being litigated, there is nothing to estop. So the decision by the criminal court to estop the state from litigating something that it wasn't litigating and then subsequently dismiss the state's indictment was improper and should be reversed by this court. Thank you, Your Honors.
Thank you, General. Both sides well argued, excellent briefs. I must say, a little bit unusual to hear a case about collateral estoppel in this court, but it's interesting.